With my please, Your Lordship, I beg to mention item number 9. My lord, in this case, we had taken steps upon respondent on the private respondent, Your Lordship. However, the office note shows that the notice has returned unserved, Your Lordship, in respect of private respondent, Your Lordship. So my lord may give us 3 weeks time, Your Lordship. In the meantime, we'll ascertain the proper address and take fresh steps if we may.
Rather than swim through the land council opinion on behalf of petition. This submitted as per office note. The service is still awaited for. You want to take fresh steps or it can be awaited.
We'll ascertain the address from the petitioner, Your Lordship. The matter may be listed after 3 weeks.
Still awaited in this regard. It's submitted. Petitioner, the fresh steps will be taken on to respond number 2 by collecting the proper and the correct address of this respond number. Let the matter be accordingly listed after 3 weeks.
Much obliged.
Mention. I beg to mention item 11, my lord.
11.
My lord. 11. My lord. With consent of other side, my lord, may I pray that this be listed after 3 weeks, my lord. I have instruction from my client to engage some senior lawyer in this case, my lord.
This
3 weeks, my lord.
PC Act is involved here.
Yes, my lord.
With the consent of the other side, the landed council for the petition, Mr. Alpame is requested for an adjournment. Let the matter be. How many weeks do you need for
Pardon?
appointing the new council?
I'm,
Senior council.
Yes, my lord. I'm in process of engage some senior council, my lord.
Yeah, definitely. How many weeks you want?
3 days, 3 weeks, my lord.
3 weeks.
Yeah.
Let the matter be listed after 3 weeks. Was there any interim and on?
No, no interest.
3 weeks.
Always.
Mayor, my lord. I would like to mention one second appeal to be listed tomorrow.
What kind of question? Appeal?
Appeal, yes, second appeal. It is for framing of issues, my lord.
No, it won't be.
Day after
Listed
tomorrow.
No, day after tomorrow, not at all possible, but tomorrow will not be possible. I think. So maybe it listed on, at best on Monday.
My lord,
May I plead, madam? I'd like to mention item number 2, madam.
Hmm.
This matter may be fixed after 2 weeks, madam. So I've taken consent from the respondent, madam.
Taken consent of the other side.
Yes, madam.
With the consent of the other side, so the land council, you're for petition.
Yes, madam.
Wait for 2 weeks time. Let the matter be listed 2 weeks.
2 weeks.
Accordingly be listed after 2 weeks. You are paying for the other side.
Lordship, I beg to mention item number 14. This matter may be taken up after 2 weeks here.
Because otherwise it's a ready matter. Paperwork is also ready.
Yes, yesterday I have received.
We need some time.
Yes, sir. After 2 weeks.
Heard Mr. Stanford, the landed council for the appellant, and also heard Ms. Kenhagi, the landed additional PP, appearance state respondent. Paperwork is ready, as well also received in original. However, the request of the council for the appellant, let the matter be listed after
2 weeks.
2 weeks.
Obliged.
Lordship, I'd like to mention item number 3. Lordship, my senior advocate, K. Tama, he has been impacted by the flu.
He
So
is
he
not
is
available.
unable to. 3.
Item
He has
number
been-
3, he is not available.
He is impacted by the eye flu, Lordship.
Huh?
Eye flu.
Eye flu.
He is unable to attend. We have also taken consent from the other party also. Lordship,
Your good name?
B. Tato.
Huh?
Lordship, interim may
Your
also
good
be
name is
continued.
not reflected.
Yes, I'm appearing on behalf of the senior.
Heard Mr. Tieto, the landed council.
Lordship,
appearing-
interim may also be continued.
appearing on behalf of senior council, appearing on behalf of Mr. K. Tama, the landed and this council for the petition. And with the consent of the other side, made for an adjournment, stating that the Angus council is suffering from eye flu. Let the matter be listed, yes, interim was there.
Please, sir.
Let the matter be listed after 2 weeks. Interim be continued till yesterday.
Lordship, the matter will be listed after 2 weeks.
May I, my lord? My lord, I beg to mention item number 4, my lord.
Hmm.
The counselor for this matter was supposed to come from Guwahati, but due to his bad health, he could not appear, my lord. So the matter will be fixed on
His good name?
Abhijit Bhattacharjee from
His
Guwahati.
name is not reflected. I think.
Yes, my lord, because my lord, the council has been changed and he was supposed to file Vagalatnama.
He Bhattacharjee in 4.
Yes, my lord, 4.
Who stated it?
Yes, my lord. On the last prayer, on their prayer, my lord, this matter was fixed today for disposal, my lord. 4 is for cancellation of the bail granted to the accused, my lord.
My lord,
So.
council has been changed, my lord.
No, on the last occasion, as per the submission, you have submitted that one council has been engaged, so some more time was needed.
Yes, my lord.
Now again, he was saying that A Bhattacharjee,
A
was-
Bhattacharjee.
he was not earlier engaged advocate.
No, he was not.
Again, he is newly engaged.
No, my lord, he has been newly appointed in this case, my lord. So he was supposed to file Vagalatnama today, my lord. But due to his bad health, he cannot come, my lord. My lord, I'm seeking for the fixed date, 18/8 August.
Had Mr. J. Sering the learned PP appearing on behalf of state. A special PP is also there.
Yes, my lord. I'm representing SIT on behalf
One
of
in
SIT.
this, yes. They are appearing as a special PP for SIT and also had your good name.
T. Umbe.
I also have so the learned counsel appearing on behalf of the respondent, and it is submitted that the namely and his counsel, Mr. A. Bhattacharjee, was supposed to file Vakaratnama today, but due to his ill health, he could not file the Vakaratnama and accordingly paid for an adjournment. Let the matter be about 18th, you are
18th.
18th of August.
18 months.
When the matter
My
will be
lord,
listed.
I may have some difficulties, my lord. I'm going out for some medical treatment, my lord.
Okay, then
So prior to 18 or post 18, my lord,
Post 18, my lord,
22nd,
20,
22.
22. my lord.
22nd. Okay. Matter will be listed on 22nd of August.
God bless, my lord.
4 and 5.
Your Lordship, I'm appearing on behalf of UDECA. He is on
Which
medical leave.
item? Which item?
Yeah. This is MAG appeal,
No, which item?
item 15.
15.
Yeah. And I need,
UDECA is not available today.
he's,
UDECA is not available today.
no, he's not, he's on medical leave.
The other side is most probably Al Parme is there and are
But he's on medical ground, he's on leave, sick.
Have you taken consent with the other side, consulted with the other side? No.
I think he has consulted. So within 2 weeks' time, no short notice.
Hard Mr.
So probably 23 or 24 of this August. If we can
Huh?
do.
Yes,
23 or 24th of August, one of the day.
hard Mr. Learned Counsel appearing on behalf of and his counsel, Mr. UDECA, and it is submitted that. What he is not available or the outside station or is
So
there?
he's available, but he's sick. His eye problem he has.
UDECA, but due to his appearing on behalf of and his counsel, UDECA, and submitted that due to his eye flu, he could not appear before the court today and accordingly prayed for an adjournment. Prayer out, let the matter be accordingly listed on you on to 23rd or
23rd or 24th, one of the day.
that we cannot say because lots of things are already been fixed. It's a hearing matter, what was supposed to hear the matter today. But adjournment cannot be 23rd. of it. After 2 weeks, go it after let the matter be listed after 2 weeks. It will be listed after 2 weeks, otherwise it will not be possible.
Number 1. Please, your lordship. This is the application under section 482 CRPC for setting aside and crossing of FIR dated 12/4/2023 arising from Pasigat PS case number 19 of 2023.
It is under section 306.
306.
What is the, it is still under investigation or
It is under investigation,
still under investigation?
still under investigation, and Accused was granted 3 years bail by this honorable court
Okay,
on 4/5/2023. That is in annexure to page number 1314. Here, your lordship, it is seen that there is no any ingredients that the accused was directly or indirectly involved for committing suicide of the complainant's wife. If your lordship allow, then may I read the FIR?
it's okay, but the respond number 2 was the informant.
Informant, husband of the victim.
Huh?
Husband of the deceased.
Husband of the deceased.
Deceased.
Is
At this stage, my lord, the notice may go to the respondent number 2.
those investigation is still under process.
Yes.
Hard question. Your good name?
A Bhattacharya.
A Bhattacharya. Learned counsel appearing on behalf of the petition or Mr. J. Sering, the learned additional LPPP. And for the state respondent number 1. Issue notice to the this is an application section 7 issue notice to respond number 2. That's informant. To register data and as usual process, the matter. We can call for the scan copy of the LCR. Scan copy of the LCR also be called for, let the matter be accordingly listed.
Scan copy of the CD.
It will,
CD, scan copy of the CD.
yes, a scan copy of the CD. It will take 3 weeks or 4 weeks. time.
4 weeks, your lordship.
4 weeks.
4 weeks.
This after 4 weeks.
Okay.
May I, Lords?
Yes.
Before this, I want to point out on the issue of delay with us, before I go into the merit. This is a very checkered history. Therefore, we have filed one delay condonation application, but later on, in view of this judgment, the registry says you need not to file the delay condonation application along with the CRP. Kindly come, Lord. The page
So
7.
delay consolidation has been registered as separate I or.
No. Along with this, we filed one interlocutory application for delay condonation. But in view of this order passed on 19/6/2023, my lord will kindly come to page 73.
73.
73. Last page. You know what had happened was that SO was filed without framing the question of law. So that was a defection. But kindly come to last paragraph, last page. Accordingly, the second appeal against the order is permitted to be withdrawn with a liberty to file appropriate application if so advised. Within this, there is a limitation. So this I want to clarify because my lord will suddenly ask me a question about what about the delay, Mr. Tara. So that is the my lord, without indulging my lord to the brief in training here and there. Well, what had happened was there was a land dispute between father and the son.
Father and son.
The father and the son. Then thereafter, what had happened was there was a Kawa decision that was on 14/12/1987. 14/12/1987. Then that land was parted to the petitioner. Well, for brevity, will kindly come to page 21. Just operating portion also. We'll come to the type copy at page 22. As per CO order, I'll not read that 1, 2, 3, 4, 5, 6, 7. Kindly go 7th line. Sri Horjum Kamki, no one shall enter without prior permission from Horjum Kamki, which was agreed by the parties. It was further decided that Sri Jungir Kamki should sacrifice a pig to his father and give 1 brass plate in consideration of land. The area of land parted as was 100 into 100 square feet. So this is the Kawa decision. Or that is on 14 December. Now, my lord will come to next page, page 24. Annexure 2, my lord. 23 is the annexure 2 type copies at page 24. My lord. So, my lord, in between what had happened was, there was a interpolation, per se, the insertion of a wrong word, and that was clarified. My lord will kindly come page 24, 8 January 1988, my lord, date is. As per Kawa decision, copy available in this office, you are allowed to inherit from your father. Orjum Kamki occupy 100 into of land with Kipe Dige. The word Siru Pele did not mention in the original Kawa decision copy, but unfortunately word Siru Pele added by some vested interest. My next page, it is clear the title was in my favor. So that is 1988, it was decided in my favor. Now, my lord will kindly come to page 25, that is annexure 3. My lord, I am taking my lord to the annexure because I am praying for the interim order. My lord, this is the this father agree by this decision of the Kawa. The father approached to the circle officer. So then there was a notice. Siodara, that is circle of ESC 11/01/1988. You are hereby directed to abide by the Kawang decision number so and so dated 14 December 87 and not construct any structure in the Ruasi field of Orjum Kampi. You will construct your residential building only in test spot identified by the Kawa members on 10/12/1988. So that the dispute was raised to end there. Now, in the meantime, what had happened was the Kawa was held. Page 28 again. Today on 20, that is dated 20/01/1988. Today on 20/01/1988, a Kawa was held to settle the Ipo Digo land dispute in between father and son. The underdeveloped portion of the land was declared in favor of Sri Jumge Kampi here, the applicant, for construction of his dwelling house and granary house. The length of his plot shall start from Iru River to boundary of Sri Karmo Nosi, and the breadth of his plot shall start from main road to the land of Sri Karli Kamki. The aforesaid land was given to Sri Jumge Kamki, being the eldest son. So this is the Kawa decision. So up to here, there was no dispute on the title of my land. Now the dispute started from page 29, annexure 5. What had happened was that from Alo Milot to Mejuka, that double laning road construction started. And then the notice was issued to all the land affected person, so as to enable them to claim the compensation and then to pay the compensation by the authorities after conducting the assessment. So, Mara, this is the notice 12 June 2012.
2012.
Yes, this annexure 6 is not very clear. A type copy starts from page 33. Now, what had happened was, pursuant to this notice, 27 December 2013, pursuant to this 12 June 2012 notice, all the petitioner was also, applicant was also asked to submit detail of the land documents, and thereafter the additional deputy commissioner, Khamba, which exercise independent power, being an independent ADC headquarter. So then this notice was asked for, kindly come to page 33, the type copy of the proceedings. I'll only rely 2 pages, my lord, and then the finding I will take, my lord. That is 27 December 2013, my lord, date is. My lord will kindly come to paragraph 2(3). Sri Nyajul Lowam HGP was heard. He submitted that in 1990, there was a Bango label kebab for distribution of ancestral land property, which was initiated by Horjam Kamki, and in that kebab he was present, and all his ancestral landed property was distributed among 3 brothers. That is what has been held in all the title decisions. But contrary to that, my lord, the sole respondent has produced one document claiming the purportedly a kebab was held between the father and the sole respondent. So in between, my lord, what had happened was, they kindly come to page 35, my lord, the finding portion.
30,
35, my lord. 35.
35.
Yes, finding portion. After careful considerations and hearing the case, it is seen that whatever the dispute sale of land happened before 2/9/1990 was joint property, not property distributed by name. The owner of the property affected after 2/9/1990, that it suffers from it, that is after distribution of ancestral property through a local body kebab. Therefore, Kebab decision 2/9/1990, the land given to Sri Modo Kamki falling between Sri Jumde Kamki and Karmonoshi measured 115 feet stands valid. Compensation amount for this part be paid to Modo Kamki. Now here the compensation has been paid to the Modo Kamki. My lord will kindly have this right to fair compensation for a moment. It's okay, I'll refer to the lord. That, my lord, what happens is, in this case, what will happen? Now, under the Land Acquisition Act, after Amendment 2013 Act has come, which was made which came into force from 1st April 2013. So there, what will happen is, my lord will only peruse the section 11. Now, what happens once this notification is issued and the survey is conducted, and in the event when there is a dispute of the ownership of the land, now the district collector, here it will be the case of additional deputy commissioner, but the additional deputy commissioner is not defined in the definition clause of the 2013 Act itself, meaning thereby the additional deputy commissioner instead of deciding the title ought to have referred to the deputy commissioner, and the deputy commissioner in invocation of section 11 would have given the fair opportunity to both the parties, my lord, to establish their title over the land. And my lord, again, my lord, we'll kindly note that under section 11, the deputy commissioner is not empowered to decide the title. Now, in that, even what happens is under 2013 Act, under section 69 or the 74, my lord will read that particular thing, or I can demonstrate from the order passed by the learned CGM. My lord will go through that section 69 and 74 for a moment. Where is that? Yes, so what happens? This is with regard to determination of the award. Section 69. In determining the amount of compensation to be awarded for the land acquired, including the rehabilitation settlement entitlements, the authority shall take into consideration whether the collector has followed the parameters set out under section 26 to 30 and the provisions under chapter 5 of this act. In addition, these are all explanations. Now, what happens is section 74 is also there in the meantime. Yes. Then otherwise, my lord, when there is in that event, my lord, the section 74 comes. In the form of appeal also, one can approach to the High Court. So here, my lord, the the learned additional deputy commissioner has faulted by himself, uh, assuming the jurisdiction of a regular civil court. But my lord, can you recall that 2013 of 4 GLT, page 1109, paragraph 32 and 34, the Registrar General versus Union of India. So by that time, what had happened, the judiciary was separated from the executive. Therefore, in hiatus, my lord, the subsequent judgment that came into was Navum Nikum. It is, I just forgot, remember the name, but Navum Nikum versus State of Arunachal Pradesh. So in that judgment, I was one of the councilmen who argued on land that till this AFR is suitably amended, the appellate authority let the deputy commissioner and assistant commissioner under section 38 or the 46 be allowed to continue to function as the appellate authority. And that latter point of time, my lord, by the grace of God, I became additional AG during president rule in Arunachal. And that Civil Code Act was finally drafted by me. And it was sent to the Guwahati High Court Rule Committee. But it took so long, my lord, but there was some error because it was very hurried. So therefore, my lord, this is one order. This ADC order is a quorum non-judice order, because he has exceeded the jurisdiction. My lord. That is the legal parlance we call is quorum non-judice. You do not have the power and jurisdiction to decide the title, but you have decided a title. Now, my lord, kindly come to Annexure 7. My lord, that the Kava decision 1990, we only came to know when the existence of this Kava decision 29/1990, only after the learned deputy commissioner asked us to file and this order was passed. Then we got this decision, which was held between the private sole respondent and the father of the applicant here in Milan.
But the order of deputy commissioner, additional deputy commissioner was passed on this year 2013.
Yes, yes. So
It
therefore,
was on 2013.
yes.
Thereafter,
Only I came to know about the existence of 2990 purported Kava decision held between my father and the sole respondent below. Now that then thereafter, will kindly come to page 39. 39, Annexure 8. Now I preferred an appeal before the deputy commissioner against the judgment and order passed by the learned additional deputy commissioner Khamba, passed on 26 December 2013 in connection with the Land Acquisition Act. So now what had happened was pursuant thereto. Now it was not disposed of even that this is only for the reference my appeal to the deputy commissioner, kindly be noted, that is 30/12/2013. Saying that the 2990 Kava decision, I am not aware, and the learned additional deputy commissioner has exceeded the jurisdiction, deciding the title in favor of the sole respondent. To that extent. Now, my lord will kindly come to. Then what happens? Annexure 9 is relating to information that I sought in order to establish what has gone wrong while deciding with this, and all those documents were furnished. So now what had happened after that? After that, my lord, kindly come to page 47. That is Annexure 9, my lord. Series 9 series. Page 46/7 is the type copy. Now here, the learned deputy commissioner through the LRSO by order dated 19/8/2014 writes a letter to us clarifying subject payment of compensation to Sri Modo Kamki village Khamba located at Bego Kamki, Chinese number so and so to for 40,915. In this case, although the amount is very small, but the implication would be whether a order made in inception is not challenged and cured through the competent court having the jurisdiction, that will have a validity, my lord. So that is likely to affect my title, my lord. So for this purpose, what the learned deputy commissioner writes to me, my lord, with reference to above, it is to inform you that ADC Khamba has submitted NOC undertaking along with judgment order dated so and so, 7th to 2014 to pay compensation to Model Company located at Dago Company, Chennai number so and so. You have submitted an objection appeal against the payment of compensation to Model Company without any relevant document. So here again, my appeal was dismissed by the deputy commissioner. That's 19/8/2014, by which my appeal was dismissed. Now, again, my lord, the intricacies of intricacies of the legal procedures has again defeated me. Then I went to the Honorable Chief Judicial Magistrate cum civil judge. Hello, I prefer this. Page annexure 10, page 48. This is a title suit number 4/2014. Page 48. Now, my lord, what will happen when the type copy is at page 40, or my lord, I can, if my lord the copy is visible, then I can read page 48.
Can,
Yeah, 48, annexure 10. Will only 3 paragraphs there. This title suit, I read from this. This title suit was filed by the plaintiff under section 5 and 6 of the Specific Relief Act 1963, praying for declaration of title, ownership, right, and possession of the Dago land located at Dago Company Village, and for directions to the district collector, ADC Khamba, for payment of compensation amount against the acquired land of the plaintiff by the government, which was wrongly paid to the defendant. It appears to this court, without going into merit of the case at this stage, that the land in dispute has been disposed after passing order dated so and so by the ADC Khamba, West Siang District, Arunachal Pradesh, for the purpose of construction of Trans Arunachal Highway. In order to allow any suit under section 6 of above Specific Relief Act 1963, plaintiff has to file the suit within 6 months from the date of dispossession as per section 2 subsection 2 clause A bracket clause of above act. But here in this case, suit was filed on 12/12/2014 after passage of more than 11 months, due to which this plaint is hit by above subsection of the section 6 of the act, that is limitation act, because any appeal has to be within a period of 30 days. But in letter decision, it can go up to 90 days. That is what is provided in order 8 of the CPC. Now kindly come to the finding of this the learned court below. Apart from this, as per section 74 of right to fair compensation and transparency in land acquisition and rehabilitation and resettlement act 2013, any person aggrieved by the award passed by an authority under section 69 could file an appeal to the High Court. That is what, in this view of the fact, next page 50, in the wrong forum. The learned court below says it is a wrong forum. Rightly, the finding here, I'm not finding any fault with the learned court below. The learned court below's finding is absolutely correct, because by virtue of the section 11 and section 69 of the right to fair compensation 2013, the learned deputy commissioner ought to have referred to the civil court to decide a title. So the finding is correct below, the learned court below. So what will happen? Then what happened? After this, the representation was there, we find the deputy commissioner was not acting upon these page 52. This read petition came to be filed. Read petition number 228/2015. And by an order dated let me have it. Now, my lord, by an order dated 4/6/2015, my lord, kindly come to the paragraph, last paragraph, operating portion at next page 56. Be that as it may, this read petition stands disposed of at the motion stage itself with a direction to the Deputy Commissioner, West Siam District, allowed to dispose of appeal in questions so filed by the petitioner. If the same has not yet been disposed of within a reason, with a reason and a speaking order within a period of 2 months from date of receipt of certified copy. Now thereafter, again, we have submitted our certified copy at page 57, 11/6/2015, we submitted. Now, thereafter, this order came to be passed, the impugn order. This is the impugn order, main impugn order. Then here, the reasoning so given is not in consonance, kindly, this order dated 5/10/2017. Without appreciating the record that has recorded, my lord will kindly come to page 59, straight the finding. My lord will kindly come before the finding, even though, my lord will know that, even though as per Land Acquisition Act, no jurisdiction lies with the Deputy Commissioner against appeal from the Land Settlement Officer as per direction of the Honorable Court, the case was heard. Now here also the Deputy Commissioner has committed error in jurisdiction, my lord. He admits in this order itself. Then here, the decision he gives since the case, my lord, decision. Since the case was disposed of by ADC Land Settlement, was upheld by DC West End District by so and so, the case is disposed of by this order. So therefore, my lord, it is authorized, my lord. No jurisdiction vested upon the learned additional Deputy Commissioner or the Deputy Commissioner to decide the title. We are not quarreling for that 40,000 rupees. But the quarrel, the question of lease in the form of law is that how come you have decided a title? You are not authorized person. So then, what had happened, this aspect of this I'll not go through. Now, what had happened, this SO was filed at page 62. SO number 2 is stroke 2017. Against this, again, in this, although I have argued the matter, but then I have not laid my hands while filing this. I came as an arguing counsel here, So then invoking the wrong provisions, because this should have been under 227 read with 115. So then what had happened, finally the matter was heard, on 19/2/2021. My lord will find this judgment, why this is important. This was allowed in my favor. My lord will come that paragraph 8, page 64. That is also not very required, but important, because the proposition that I was arguing, the learned additional Deputy Commissioner and the Deputy Commissioner does not have the power. This is the finding of the court at para 8. Just the petitioner has claimed that under right to fair compensation and transparency in land acquisition, rehabilitation, settlement to the insorts, Deputy Commissioner, additional Deputy Commissioner does not have the right to decide a title of the land in favor of any individual. And this is the issue on which the present appeal has been filed. That wrong provision was quoted. My lord is aware that Surya Devi 2006, 2003-6 SSC, page 425, paragraph 16. And thereafter, that law was not in a correct proportion. Then, that 2015, Radhesham Chabi, 2015-6-7 SSC, page 425. In that judgment, the distinction was made that while filing a application before the High Court, in the Constitutional Court, the petitioner are not allowed to invoke two provisions. So most of the time, we as a council, we file 226, read with 227. Now later on this Surya, that Radhesham judgment has clarified. So therefore, that 227 is maintainable against this order passed by the executive officer in exercise of their administrative power. So, my lord, then what happened after exhaustive hearing? My lord will kindly come to para 17 is the operating order. 16 and 17 is very important, my lord. Para 16 and 17. 17, my lord, I am reading for the purpose. Be that as it may, this court has reasons to agree with the pleadings of the appellant that impugn order dated 5/10/2017, holding that the title over the dispute land belongs to the private respondent is valid in law, because under the existing law of land, the deputy commissioner is not entitled to decide a title of an individual over any property. For this purpose, a civil court is a proper authority, my lord. So accordingly, my lord, that was interfered. Now, my lord, the next question comes. What had happened? The sole respondent in this case filed an review petition, my lord, of this judgment, saying that no, without framing the question of law. Well, section 114 of the CPC is very clear. When you are filing the second appeal, my lord, the question, framing of the question, substantial question of law is a paramountcy. And if you don't frame the question of law, my lord, then your appeal is devoid of the merit and it has to be set aside. Katina or judgments, my lord, that I will not bother. So, my lord, then what will happen? This 17/1/2023, the review was allowed, my lord. Because on the ground that review was allowed, my lord. So then this goes, my lord. Now, but the finding of the court remains, my lord, at para 17 still. So therefore, my lord, it becomes a, my lord is aware of that coordinate bench decision, so I will not rely on that. So that come as a style decisions in order to maintain the judicial discipline, my lord. That's all, that purpose, my lord. So then thereafter, what had happened, my lord, I was not there. So then finally, when I cross-checked with the law under CPC, my lord, the finding of the Lordship Saikia in the review application, I found it to be correct in law, my lord. Because there, the read petition, the SO was drafted and filed in a very hurried level, without framing the substantial question of law. So in that case, if this court proceed with this case and adjudicating the matter finally without framing the question of law, and if it is brought before the Honorable Apex Court in SLP, the credential of the bar and bench would be questioned there in the Apex Court, my lord. So therefore, my lord, for the perfectness of law, my lord, when I check the law, the procedure that we have adopted filing SO is inconsistency with the provisions of the law, then I venture to withdraw the SO. So therefore, my lord, this read appeal, my lord, this civil revision, my lord. No, my lord, kindly interfere with this. Money part we are not saying, except for time being. And then if required, we will, both the parties will approach the appropriate forum.
Now you have filed this revision against which order? This one, 7/1?
Yes, yes.
17/1,
Yeah, no, 5.
Huh?
5/10.
5/10?
Yes. That impugn order passed by the deputy commissioner. Page 58 below. 5/10/2017. Only this much, my lord, for let kindly interfere with. We are, my lord, we are a family only, but we are not disputing on the amount, my lord. Only to the title. Till such period, my lord, the families might have sit together again.
So
And
as
settles.
the interim, what is your prayer? Is it-
Only to suspend this operation of this order. 5/10/2017. Page 58, my lord. And which was earlier was and set aside in this SO number 2, my lord. Which was passed and set aside in SO number 2, my lord, 2007. Well, this much only because it will not,
If it has already been set aside, so what is the issue now?
no, my lord. This order was reviewed, my lord.
Reviewed
Reviewed.
and?
And thereafter, the question of law was not framed. Because only option that is left with me is order 23, my lord.
No,
With-
yes, question of substantial question of law were not framed.
Not framed, my lord.
So that
Then there are-
filed in review.
No, yeah.
Yes,
Yeah.
Then,
They filed the review,
yes,
the review was allowed,
yes,
and meaning thereby the case decided in SO2 my lord,
yes.
become authorized, my lord,
Right.
is inoperative.
Mm.
Then I realizes, yes, there is a defect in the SOA. Without framing the question, substantial question of law, we should not approach the court. Then it was withdrawn by me.
It
That
was subjectively withdrawn by you.
it was withdrawn by me, therefore this revision now. Only whether it will not cause any prejudice to any of the parties. Only the property as described, they are in their respective possession. Only opportunity may kindly be provided. So
But
as
your
to,
property was most probably acquired by for the
No,
construction
no,
of
no.
Arunachal.
no, some portion has been acquired. Some portion
This
compensation as
portion
well.
also includes in that.
Ye-
area or
Yes,
not?
yes.
Then in that case, by interim order, whether
Yes.
that project will be
No, project is completed, that part.
already completed.
It's not going to affect. Well, the only thing I clarify, in view of this 5/10/2017 order, imperial order passed by the deputy commissioner without jurisdiction, deciding the title, assuming the jurisdiction of a
Yes, yes.
civil court is
Yes.
perverse.
Hmm.
So then, because of that, although the compensation amount has been paid, but those land required for the highway, has already been taken, work has been completed. There is no perversity. It will not cause any, kindly to that extent, so that we as a family will sit together and hammer out a solution to this. To that as well, because if this order remains, the title will be with the other five people. Grateful.
Yes.
And I shall take the other steps. I shall take,
Pass the order.
yes, I'll take the steps.
Lordship, this is the second successive bail application.
For that matter,
Yes, your lordship.
again, you are filing a bill.
Yes.
Benjamin.
Lordship.
What is the new ground now?
The only ground that they have given is that his mother. That his parents are old age and he being the son need to take care of them, your lordship.
This is the only son.
Page?
Page number 39,
13.
unacceptable.
This is the prescription for mother.
Yes.
What kind of she is suffering from?
Actually, his mother is suffering from multiple ailments since 2018.
Okay, back pain, general sickness.
And now she has been referred to Assam Medical Corps for further treatment. But there is no one in the family.
His father is not alive.
The father is also aging.
He is still there.
Yes, he's still.
Yes, your lordship, I leave the discretion to your lordship. However, the point when the matter was unlisted, your lordship, the point raised at that point of time by learned PP was that the ground of his ailing parents was already been given in the previous mail application, your lordship. Subsequently, even in that application on oath, they have stated that his parents are 80 years old, your lordship. Now, if your lordship will come to the annexure that has been shown, your lordship will see the mother is 55 years of age and the accused is 41 years of age, your lordship.
Hmm?
Now.
That
if-
gives is 41 years.
Yes,
the accused is 41
accused
age,
himself is a 41
the
years.
mother is 55 years age, quite young, your lordship. Otherwise also, your lordship will see in terms of humanitarian ground, your lordship. Since they have come only with regard to the medical issues, your lordship will see that humanitarian ground should be in such terms, your lordship, that it compels the court to allow them to go on bail, your lordship. For example, if lordship will see for attending marriages, your lordship, or death, your lordship, or also if otherwise also there are other humanitarian ground, your lordship. For me, this ground, your lordship, as soon as the bail has been rejected, your lordship, on very next day, your lordship will see that they've come along with this.
Near the subject.
Yes, this stage, city may, updated city may be called if this honorable court deems to be.
CD, your lordship is not
No,
required,
yeah.
because on the last occasion. it was
Otherwise, lordship,
disposed of merit.
On my bail application number 68, 2023, there might have been some typographical error by mentioning the age of the parents. But here in this prescription slip also, I doubt that age might have been wrongly mentioned. Since the alleged accused person, he himself is a age of 41 years. How the mother?
What can we do?
Yes, this can be the,
What can we do?
yes.
The last order of rejection was passed on 2/8.
Yes, 2/8.
Last order was
Yes,
2/8.
last.
And this bail application is filed on
File on 6th,
6,
7th of,
7/8.
yes.
And on for which application you are saying?
On this application where the bail was rejected, your lordship.
Earlier bail application.
The
Earlier
earlier
bail.
bill was rejected on ground lordship. May I take you to the page number 37? Page number 37, far right. May. So considering the entire circumstances of the case, this case, gravity of offense and considering the report of IO. as
The
well-
earlier petition, what was the age? He described
Your lordship will see earlier petition at page number 7, if I may read, your lordship.
Page number,
Page number 7, paragraph 7.
page number 7.
Earlier petition, your lordship. The petition that has already
They
been
have
disposed of.
petition?
No, no. They have not annexed it. I'll just read because I have taken it from the
Okay,
record,
okay.
your lordship. That is why I'm stressing on this is because this was also a point that was heard by your lordship while rejecting that bail. Your lordship. It is further begged to submit that the alleged accused is an eldest, your lordship will see, eldest son of the family, and both aging parents, namely so and so, who is attending age of 80 years and currently live at Silapatar, Assam, and it has been the routine alleged accused person to visit the parents every week and look after the basic requirement. As there is no one in the family to manage the basic needs of the family, further it is fairly begs to submit that health of aging parents are getting deteriorating and there is no one in the families to take care of aging parents in case of any emergency. And the present police case against alleged accused has further worsened the health condition of the parents. Therefore, the alleged accused person may kindly be enlarged on bail in the interest of justice. This point was given in lordship.
But lordship, this was not substantiated by any record, material records.
It need not submission on oath.
And the medical treatment has been going since 2018. So I have placed the record also.
Yes, you have placed the certificates, I mean, the prescriptions.
Page number 39.
Huh?
Page number 39.
Yes,
Yes.
one prescription is there.
Yes, and page number 40. This is the medical prescription of 2018.
Huh.
Since from 2018, his mother has been going undergoing medical treatment for
Huh.
certain ailment.
Hmm.
I would not be hampering so much on this, your lordship, with regard to the prescription, your lordship. However, if your lordship will see at page number 39.
Even if you go by
Yes,
the
and
page
this-
41,
Yes,
in that case also, it seems that disco number vertebra seems to be an alignment, and it is a normal in space.
lordship,
Yes, but anterior marginal osteophysis is most probably started,
yes.
but there may be some disease.
Yes, sir.
That much only.
Lordship, on
Nothing
humanitarian ground only, both the parents are helpless. They both are sitting helpless in the house. They are at Assam, Silapatar, and the alleged accused person
He basically reside there in Along. Now he is linguisting at the district jail Pasigat for last 30 days. Even prior to the arrest of eligible person, the eligible person used to take his parent to the hospital. This is the prescription was the medical doctor was consulted on 10th of July. So in this stage, Lordship, the eligible person may kindly enlarge.
Even in with regard to the prescription, your lordship given on 10/7/2023, your lordship will see on the left,
Otherwise, Lordship,
left hand side, the uh, there is a record of the doctor as to what illness, your lordship.
Is weakness, is there general weakness?
Yes.
Third, Mr. R. Inwood, Development Council for the Petition, Mr. M.S.T. Daily, Development Additional PP, appeared on behalf of state respondent. And this is an subsequent bail application files on behalf of Sri Deepak Hazarika.
Lordship.
Accused is Deepak Hazarika.
Yes, Deepak Hazarika.
Accused Deepak Hazarika, who is languishing in jail hazard in connection with Pasipat Police Station case number 51/2023 under section 302/34 IPC. It is submitted by the Learned Counsel for the petitioner that the present bail application is filed subsequently only on the humanitarian ground that his mother, his aged mother is either unable to look after his old aged ailing mother, who is also suffering from various kinds of diseases. And to substantiate the same fact, the Learned Counsel also submitted 3 numbers of medical prescriptions that showing that his mother is ill since last 2018. But it is submitted that his father is also a aged person and is not in a position to look after his wife as mother of the accused. Accordingly, considering the head ground of the murder of the deceased and on humanitarian ground, the present bail application should be allowed. The accused is a permanent resident of his at-risk locality, and hence there is no chance of absconding if he is enlarged on bail, and will cooperate the IO in further investigation of this case, as he also he also wants that the main culprit should be booked or in connection with this case. In this context, the Learned Additional PP and Ms. T. Ginny has submitted that in the earlier bail application, which was rejected by this court on 2/8/2013, the same ground was taken. The same ground of illness was taken, but that was not but his bail petition was rejected by this court, considering the other incriminating circumstances and the incriminating circumstances, and which a view that further custodial interrogation may be necessary for the interest of the investigation. She further submitted that in the earlier bail application, the age of the parents was mentioned as nearing 80 years. However, in the present petition and the prescription shows that his mother is only 55 years of age, which is and thus she is not so old as claimed by the petition. More supposed to. For this, it is submitted by the learned additional PP that considering the humanitarian ground should be in a manner when the court is compelled to give bail in this and in very in considering the urgent circumstances of the case. But here in the instant case, it is seen that the illness which has been prescribed in the prescription annexed as annexure 5, 6, and 7 also does not speak about any does speak about serious illness of his mother to allow the accused to go on bail at this stage. After hearing this submission made by the learning counsel for both sides, I have published the report and as well as the annexures while along with the petition. It is seen that on 2/8/2023, the bail petition for this accused was rejected on basis of the case diary and the relevant documents, also considering the report of the IO as well as the gravity of the offense and the stage of investigation of this case. It was observed that the investigation for the purpose of just and proper investigation, further custody interrogation of the accused may be necessary in this case. Next one. Coming to the ground taken by the petitioner, that is the illness of his mother. It is also seen that from the prescription which is annexed in the along with the petition also does not speak about any serious illness of his mother, nor there is any mother, and the age of the mother is also mentioned as 55 years. And it is also, and it has also come to the notice of the court that the father of the accused is still alive, who is with her, which is ailing mother. So considering entire circumstances of this case, I find that the present bail application, which is filed mainly on the humanitarian ground, cannot be considered, and accordingly, same stands rejected. Your petition is rejected. And yes,
Arising out of the same FIR, Lordship, same case, but my ground is different, Lordship. My wife is 8 weeks pregnant, Lordship. I have annexed the copy of it. Page 30, Lordship.
Page?
This is the Mother and Child Protection.
No,
Card.
page.
Page 30, Lordship, Annexure 7 series, page 30, Lordship.
Yes,
Lordship, this is the card normally given to the pregnant lady if she happens to visit the hospital after conducting the test and all. This card is normally provided. This is the card, Lordship, Mother and Child Protection Card. Lordship, may kindly come to page 31. There are some medical terms we normally fail to understand what is written, but I'm told that she is 8 weeks pregnant, Lordship. In the second paragraph of the prescription,
8
Lordship will say 8 weeks. Lordship will find page 32 is the ultrasound still, and then page 33 is 8 is important, Lordship. Finding of the ultrasound, Lordship. We'll see 8 weeks in the second line, Lordship. Lordship, I was living with my wife before I was arrested, Lordship. And my wife is housewife, Lordship, having a small child. And recently I'm through visiting medical, Lordship. She is 8 weeks now. We find that she is 8 weeks pregnant, Lordship.
So therefore, Lordship, on this very ground, Lordship, I'm approaching your honorable court, Lordship.
If I may, your lordship, only certain points, your lordship, will see that their date of arrest was on 7/7/2023, your lordship.
Yes.
The certificate issued is of 13/6/2023, your lordship. Now, she must be more than 8 weeks. If any complication as such with regard to the present, your lordship is well aware that even though in pregnancy, there is a need of care, there's no denial to it. Your lordship, if there is any complication or whatsoever, otherwise mother is good caretaker of her own self, otherwise, your lordship. Prior to arrest, certificate was issued on 13/6/2023. Now at this present stage, your lordship, because he was arrested on 7/7/23, your lordship. Now at this stage, status report of if any, your lordship.
Lordship, solely on humanitarian ground, I'm approaching Lordship, since my wife is pregnant, Lordship. Lordship knows that at the time of pregnant, the lady needs the support of the husband, Lordship. So I am before you, Lordship. Lordship, the CD may be called for, Lordship.
No, CD, what will leave it, CD? CD will reveal nothing.
Lordship,
On
only,
the basis of the CD and the last second of this August, I
Yes.
think it was rejected. So they will take some time. CD will not reveal anything.
I'll leave it to
CD
your
will not-
Lordship.
CD
This
will
is
not
only one ground that solely on
Because
humanitarian
there may
ground.
be a gap of suppose 15 to 30 days, that may be one of the ground for calling the CD, but within a week or not even a week, what purpose will serve by the CD? That is-
Lordship, last occasion, if I may, Lordship, last occasion, the bail was rejected on the grounds saying that certain CCTV footage and the CDR was to be analyzed. Analysis of this very CCTV footage and the CDR was to be done. Lordship. By now, Lordship, it will not take it will not take much time, Lordship, to go through all those CCTV footage.
If you insist for calling CD, then it will be fixed on 17 or 18th of August, not before that.
Lordship, I have approached before your honorable court. The simple reason is, Lordship, since earlier bail was rejected by this.
Then I will take up your bail letters from the principal seat only. We don't have it out. On Friday, we are not going to keep anything here. Not at all. It can be 17, 18, and I can can be listed after. On
Lordship,
virtual mode, I can take hearing.
Lordship, I leave it to you, Lordship. You can fix it after 2 weeks or maybe 1 week, after 1 week or 10 days or 15 days. Lordship. I leave it to you.
But this cannot be done. The earlier matter was rejected.
Lordship, I agree, Lordship. I humbly agree, Lordship. Solely on this ground, Lordship. On humanitarian ground only, Lordship. I leave it to you, Lord.
Yes, Ms. Rini, any other?
We can fix it.
No, your lordship, only with regard to, since your lordship, the pregnancy I have already submitted. I might be wrong on my part when I submit such things, but then support is needed, absolutely. But then just because the certificate is of 6/6, your lordship, the statement is, government has also been stated that 8 weeks. Now, if there is any, because prior to his arrest, during his arrest of 30 days, the wife has been taking good care of herself, your lordship. Now, subsequently, there is any certificate to her pregnancy, your lordship, or any complication whatsoever, your lordship will decide on that, your lordship. However, the certificate says prior to his arrest, during entire his arrest, she seems to have been taking good care of herself, your lordship.
Lordship, may I
Because-
suggest-
because
suggest,
her-
Lordship, we can fix it after 10-15 days, Lordship. Immediately, Lordship. By that time, Lordship, if Lordship feels that I need to come up with updated medical prescriptions, I can bring it. Lordship.
My only terms with that is, your lordship, we'll see that successive bail application, the only ground taken is medical
Yes.
medical ground. There is no question of reviewing the merit of the case again, your lordship, until unless our investigation team comes with a charge sheet or any finding whatsoever, that can be a substituted ground, your lordship. However, present, your lordship is dealing only with the ground of pregnancy of a woman, your lordship.
Okay. In that case, your petition is rejected. By the case.
Lordship, I may lordship, we can fix it after lordship, 10 to 15 days lordship. After 2 weeks lordship.
What purpose?
That
is
also
it?
Because,
can-
yes,
can be done.
because
By the time lordship, at least
Only
Because-
one thing can be seen. That even if suppose on the 15 or 20 days check, if it is suppose it is fixed, then we can see the progress of investigation that much.
That
Not-
much only.
not more than that.
yes, but progress of investigation also your lordship will see, when I'm stressing on that is your lordship will see that with regard to the process, your lordship, that, see, even if the CD is called for your lordship, that has to be a new ground raised by them, your lordship, in their successive bail applications subsequently.
Okay, it is rejected. We have it.
All right.
Rejected. Order.
much.
Court of law and hard to order to prohibit the hard to not be. Hard Mr. Jayaswamy, the London Council for the petition also hard Mr. MST Jill, the London additional PP appearing on behalf of state respondent. This is a subsequent bail application under section 439 CRPC. For release of the accused person, so and so, in connection with Pasika PS case number so and so, the section so and so. So it is submitted by the London Council for the petitioner that the subsequent bail application will be filed only on the ground of the medical, not only on the ground of the medical issues of his wife, who is at present more than eight weeks pregnant, and accordingly he also furnished the medical certificate along with the along with the report of the sonography, etc. Along with his petition. It is submitted that his wife is a housewife and she is pregnant and there is no one to look after her at this critical condition. And apart from that, he has also a minor child who is also to be looked after by his wife. The petitioner along with his wife was residing separately, and hence at present there is none to look after his pregnant wife. He is a permanent resident of his address locality and will appear before the court and will cooperate the IO in the further investigation of this case, as he also wants that the actual main culprit or actual culprit behind the murder of his friend should be booked by the police. In this context, the learned edition PP MST has submitted that the medical report, which is annexed in the along with the petition, is of 13/6, 2023, and by this time probably and by the time she may be more than 8 weeks pregnant, but there is no this certificate showing any complications of her pregnancy at this stage, and hence it is submitted that without any urgent ground, the present petition or the subsequent bail application cannot be allowed only on humanitarian ground. Next paragraph. After hearing the submission made by the London Council for both sides, I have perused this record as well as the annexures of filed by the petitioner showing the pregnancy of the wife of the accused. It is seen that as per the medical reports, that's the pregnancy report, the wife is 6 months, 8 weeks pregnant at the present, 8 weeks pregnant, and there is no abnormality or complications are shown in the cause list, in the prescription issued by the doctor, nor there is any complications seen in the report of the ultrasound. The last application for bail was rejected by the order dated 2/8/2000 in 2023, and hence, without any urgent or new ground, the subsequent bail application cannot be considered. When the earlier bail application was rejected, considering the stage of the investigation, gravity of the offence, as well as the considering the report of the IO system. And hence I do not find it proper to allow the present bail application only on the medical ground, which is taken by the petition. Will be appropriate substances as well.
Much of.
My lord, this is an application under 482 for washing of FIR.
Washing of the-
Yes, this is a joint petition. Your Honor. Filed
The
both
joint
by the-
petition,
Yes, complainants and
Huh?
co-accused,
4 accused and
the complainants. Your Honor. Your Honor,
what was the offence alleged? 326 was there.
yes,
Have we annexed any medical report, etc.?
no, Your Honor. My lord, here,
We should call for it. Yes, Ms. Jin.
Yes, your lordship. Your lordship may call for the record.
Happy tells here, is this charge sheeted matter or?
No, Your
No, not
Still
still.
under investigation? Now they have compromised the matter.
yes,
See, allegation is under section 451 and 326. So 326, the,
Voluntarily
Matter was-
causing grievous hurt by dangerous weapon.
yes,
Only the compoundable is 427. Rest of them are non-compoundable.
rest of them are not. It's any other subject. Okay. Rather, we can call for the case diary along with the scan copy of the case diary along with the medical report. That
Yes.
will most probably help us.
Yes.
If suppose in many cases, what happens, the IO registers a case under section suppose 326, it may turn to 324 also,
yes,
maybe even 323 also.
yes.
That may be the case. So let us see the medical.
Yes.
report. Hard, Mr. Your good name?
G Kato,
G.
G Kato.
Line. Hard, Mr. G. Thakur, the learned counsel for the petition. Her name is T. Singh, the learned additional people, appearing on behalf of the state respondent. This is an application under section 2 and 2 in connection with for washing. Issue, call for the scan copy of the case diary. Case diary can be called for.
Case diary can be called
A
for.
case copy of the case diary along with the medical report of the victim. Along with the medical stress injury report of the victim. Let the matter be listed. It can be reached either by. You can fix a date. I think.
17th of August,
17th of August will come.
or 16th of August, your lordship.
16th will come.
No, no, no.
15th will
15th is-
police
yes,
officer
yes,
will be
yes.
busy na.
On 18th of August in that
Yes,
case.
let it be on 18th of August, 18th of August.
Much appreciated.
Deeply.
Your lordship, may I- this is an application under 483 for causing and surprise. This is a Luxin PS case, your lordship, under section 279, 338, 427, and 304. Out of 4 offense there, except one, all are non-compoundable in nature. This is one petition, your lordship.
The joint petition.
Yes. The petition 1 is the alleged accused. And 2 is the legal representative of the victim, father of the victim. And 3rd is the victim itself.
Victim, and there were most probably 2 victims.
Yes, 2 victims.
One died,
Yes, in 304A. Causing death by,
and the 3 was also a victim.
yes, 3 was victim. If you kindly go to the page number 34. This is a deed agreement between all the joint petition.
It is still under investigation stage or charge sheet has already been.
Charge
filed?
sheeted, you know.
Charge sheeted and before the CGM Pasigat.
Pending report.
Yes. My humble prayer is that it's maybe kindly stay for this moment right now. Because on 22, there is copy prosecution witnesses.
They have
Stage.
already appeared before the
Mm.
court, not yet.
The CC has been framed, but
CC already.
for
Your lordship, if your lordship will see that FIR was of 2012, your lordship. And the charge sheet was filed in the year 2013, your lordship. Now, at this stage, just to ascertain at what stage, your lordship, if the depositions has started or has completed, your lordship.
Can you tell us what is the stage of the proceeding at present?
Yes.
Because case is assisted, charge sheet was filed in the year 2013 only. And charge has already been framed.
yes.
So what is the stage of the case now? Witness has already been,
Yeah, they have called for, but none of the have been give their deposition before the CCM. They have, the witness has been called, but none of the witness have give the deposition before the learned CGM in Pasiket.
yes, we know what to do.
Yes, your lordship, if your lordship will see the settlement agreement, your lordship. Though it has been stated to be made on 30th day of January 2023, your lordship.
Hmm.
Your lordship at page number 35 will see a second paragraph, whereas on 2/11/2023, which is almost 11 years ago. So I'm not certain as to when the exact agreement has been made. Settlement was made.
Yes, yes. Actually, it is made on 18/6/2023.
May, yes, it ought to
Yes.
have been written in.
It is the continuation of 30 May and executed on
15/6/2023.
22 December. Yes.
Executed on 15/6/2023. It was only during the pendency of the present petition or prior to the filing of the present petition, I think. Why you were so late in entering into the compromise or settlement? Was it
Because
delay
this,
delay of matter is of 2012, delay of
Yes.
11 years.
yes,
And your petition itself, it is seen that on so and so, which is almost 11 years.
yes, actually it is,
That means almost 11 years ago, it cannot be on 2012 or 13. It cannot be at all.
it has been,
Whereas on 2/11/2012, which is almost 11 years ago,
yes,
that means it is on 2023 only, no, how can we pay?
it has been
The agreement
on
is-
2012, but executed on 2013, and this is the by the petitioner
That's what
too.
I'm saying, is all the signatures are on 2023 only. All
Yes.
signatures of 2023, 15/6/2023. And that apart in that para, it's specifically stated that 11 years ago. 11 years ago means what? 2023 itself, it comes.
No, your lordship.
Hmm?
If I may correct your lordship, the starting states that this is in continuation with the settlement agreement made on 30th day of January 2023 at Ruxin at per Midum Kaba decision given on 22nd December 2022. This present settlement deed is only the execution on day 14th of June 2022. It seems that there was a Kaba and the decision was passed on 20 December 2012. And in continuation thereof, on 30th January 2022. समझ में नहीं ये बता
उल्टा पुल्टा लिख दिया ना उसको कैसे समझाएगा?
Actually, they have settled the dispute on January 2013, and they have executed on 14 June 2002 before the is Pasiket at the Siang district on 14 June 2022.
So what is the stage of the case now?
The case is it has been charge sheeted yourself. The case has been charge sheeted, and they have called the prosecution witness on 22 on
If all the witnesses are already been
not examined,
examined,
not examined.
if you're safe, can we go? Come problem, stay corridor. Okay, we'll pass an order on stay.
Hmm.
And we'll call for the scan copy of the SCR
Hmm.
after
3 weeks.
3 weeks.
3 weeks.
Yes.
Stay may be
Because we
granted
do not
till
have-
next date. Your Lordship.
Yes, still for only for till next date, still. State will be up for, will continue till next date.
Yes, till next day.
After it will be, after 3 weeks. Because we do not know stage of it. If it had already been examined, then it will be a problem for us. Okay.
Much
Deep-
obliged.
Heart swells so political. Numbly. Petitioner side is not available.
Yes, madam. I think this would be the fifth time they are not represented.
Yes.
Madam. Yes.
Heart Mr. Yes, saying, then it will be at everyone. Yeah. Here also, we have the special BP SIT, no?
Yes, madam.
Appearing as a special BP SIT. So none appears on call for the petitioner side. It is. It reveals from the record that the petitioner side remain absent since last.
Starting from order dated 29/5/2023. They were,
But
Absolutely.
one order is a bit confusing on 3/5/2023. One order is that as paid by the learned counsel for the petition, release this matter after 2 weeks. That who was the counsel, who paid? It's not there.
yes, madam.
So that is one confusing part.
Yep.
And
The order is
Twen-
starting from 29.
Huh?
The order is starting from 29/5/2023.
29/5.
Yes, 29/5.
Yes, 29/5 we are absent.
Yes, my lord. And next date is of 16/6/2023.
Yes, it is also absent, yes.
On 4/8/2023.
4/8 also absent.
Now today even they are absent.
Reveals that the petitioner side is remaining absent since last 3 consecutive dates from 29/5/2023. Though these several chances was given to the petitioner side. So accordingly, finding no other opportunity, the present the petition stand disposed of due to non-prosecution. Dismissed for non-prosecution.
Much obliged.
My lord,
Items 6, 7, and 8 are arising out of the same,
Madam,
Case
in this
number.
case, some accommodation may be given to us since we have sought for the case diary, but we could not receive it. So some short date may be given, my lord.
yeah, your lordship had given some interim protection and all the 3 applicants, they have otherwise
They're
appeared.
seeking for short date only.
My lord, then, may I pray, my lord, then let it be after 2 weeks, my lord. Next 2 weeks, my lord, will be out of station, my lord. I have some personal difficulty. Can it be on the,
Till when you were here?
my lord, this week, my lord?
Till
This week, my lord.
only this week.
Yes, right, lord. So I-
Friday too, we cannot give.
Yes,
Monday you are not here.
no, my lord. So can it be on, my lord, September 4th, my lord, on the first Monday, my lord?
Because they are, but what I'm saying,
Madam.
they are not they are already interim, no?
Yes,
There's
madam.
already.
All are in, all in.
Yes, my lord. And we have already appeared and we are cooperating. We have already given our statements also, my lord.
Heard Mr. D. Suki, all will be same. Suki so the learned counsel for the petition, also heard Mr. Yes, the learned PP appearing on behalf of state respondent. It is submitted by Mr. Jerry, saying that the some more time will be required to take some more instructions and to submit the CD post. Heard accordingly, the late matter may be listed of 4th of, you're saying 4th September.
Yes, my lord.
4th September 2023, and till then, the interim shall be continued till next date. All are same.
Deeply honored.
Here, your lordship, I'd like to take adjournment.
Item number
10.
10.
Yes. I have only taken the consent of the respondent side.
So otherwise you are appealing for the respondent
No, I am for the petitioner
petition.
on behalf of Mr. Estapin.
Yes, sir.
After a week, maybe fixed.
So appealing on behalf of Mr. Estapin and with the consent of the he paid for an adjournment. The matter will sit after 1 week or
After a week,
after 1.
after a week. Obligation.
Well,
May I, Your
Yes.
Your Lordship, this is a joint application filed by the accused and the complainant of an FIR for questioning of that FIR.
Yes.
Is this matter has been settled outside the court amicably between the parties by intervention of the village elders Gamburas. So I pray that this affair may be quashed.
This petition was in order for.
Lordship, yes, Lordship. Last question CD was called for and we have received the CD also, Lordship.
You have received this.
Yes, Lordship.
Matter is still under investigation.
Yes, Lordship. And Lordship, accused is still responding, Lordship. And Lordship, they should have come for AB actually instead of filing for the
Still
quasi.
responding.
Lordship, we have not.
No, no, Your Lordship, the accused and
Now he is absconding and you are praying, you have come up with a petition for this, squashing.
As per the Lordship, this latest test that the case is kept pending for arrest of alleged accused and examination of more witnesses. Lordship, they should have come for the AB instead of passing this FIR.
You just do one thing. You can, most probably, she is rightly saying that you can withdraw this present petition at present and can file a fresh AB or intercepted bail application. That will help you. Otherwise, why? Because washing, now see, the position of the CD status report from the IO is that your petitioner is absconding. Is not at all cooperating, he is absconding. And in that case, how can you say that there will be a case for washing the proceeding?
May I assist, please? Yes, actually, the allegation is given in the FIR. Nothing of that incident took place.
Yes, understood. Nothing of that incident took place. Matter has already been compromised.
Yes.
All are things equal. But the question is that he is absconding.
No, Your Honor, he's not absconding.
What he is doing?
He already appeared before the IOs.
Then what is the report?
His statement is not recorded here.
That-
Lordship.
that is not recorded.
That
He is
may be so,
absconding.
but that may be so. I don't know how the IO has sent the report, but I have already appeared before the police.
Then, well, I don't know what will. Your petition will be
In that
rejected.
case,
then.
Your Honor, I pray that the next step
And
may
you can
be.
reject your petition otherwise.
Yes, Your Honor, but Your Honor, my prayer is, if that is the case, then next step may be given, so that I'll appear before the IO also. So that, instead of dismissing the appeal today. Because you know, if we look at the records and the agreements, no fight of no any incident.
Now, on the what strength you will appear before the IO because it is a non-bailable offense most probably.
Yes, but
Then in that case, what will do? What will IO will do?
you know,
Till now, you have not, as per the report of the IO, till now, you have not appeared before the IO. That is a case registered, whatever, case is registered under the non-bailable offense. Isn't it? If you appear before the IO, you will get arrested. That's why we're suggesting that you can apply for an anticipatory bail. We can keep the petition pending.
Yes,
Doesn't
yes,
matter,
yes.
but you can apply for anticipatory bail.
So that-
Anticipatory bail,
yes, Your Honor.
record your statement before the IO, then come, with CD will call for.
That is true, Your Honor.
After
but,
that CD.
Lordship.
Your Lordship, I request to kindly go into the details.
It's for pending, then you file the.
But just I help my brother. My brother has posed a serious question, absconding, and then this application on a 482. Well, this petition can be kept pending if the petitioner is absconding. Because the offense is grave in nature. So in the meantime, my brother, I'll advise you to file one anticipatory bail application.
Because the filing of anticipatory bill will most
Yes.
probably help you.
Instead of
Otherwise,
withdrawing, let it
pending.
file.
List after
Yes, Lordship.
simple query, list after. This data. it will be
Updated, updated.
updated.
CD.
Updated.
Scan copy of the updated CD, Lordship.
Pardon?
Scan copy of the updated CD.
So and so. Let us scan copy your up to date CDP call for. Matter will be listed after
2 weeks, Lordship.
after 2 weeks.
Lordship.
But can it be date fixed or for CD?
Lordship,
Because I don't know if they file, suppose if they're going to file any AB, in that case also CD may be required.
Lordship, then 3 weeks, Lordship.
3 weeks,
No.
list after 3 weeks.
You want to,
Apply
interim may be continued, interim order may be continued.
Oh, interim was there?
Yes.
No, Lordship.
So there was
What
a-
kind of interim?
Yes, there is stay,
Oh,
there is stay, yes, sir.
what stay was there?
I don't know, Lordship.
I mean, it's,
Oh,
Lordship, I have not go to the last order. It is stay or not, because in my here,
no,
I.
in returnable date, further proceeding of so and so shall remain stay. So that it is a not succeeded matter, na?
No,
So
Lordship.
they enter in this.
Lordship, maybe wrongly that order, because in my
One
record,
thing,
I have not,
Next date,
Lordship.
so I think you can file a petition for vacating this day order.
Lordship.
Otherwise, I cannot.
Yes, Lordship, yes. Lordship.
So as per him, stay, interim be continued till next day. You just file a petition.
Lordship.
How can it
Alright.
be stayed?
Like,
My lord,
21 and 22.
Matter is fixed in orders, my lord. And on the last occasion, my lord has directed the counsel for the petitioner to file a IA. Since they have come up before this honorable court on the basis of a joint petition. Since the accused is convicted in this case, and subsequently they have filed an appeal. And at the same time thereafter, my lord, they have filed an IA, saying that they have compromised the matter post conviction. So that was the issue, and they have filed the IA, I guess, my lord.
I is being filed under section 320 CRPC for
320,
2020.
Huh?
320,
320.
320 CRPC for compounding of material. 332 plus
325, my lord, subsection 5.
T20 subsection 5 is the proper heading. That I'm not sure, that's what it's in T25.
Yes, ma'am.
plus 5.
So there has to be a leave of the court.
Yes, ma'am.
Yes,
Yes, there is two table in the
leave is
320.
required.
320.
Yes, in that case, most probably leave of the court is required. Leave from the court is required. I said. Then,
But as per section 320, first table is no required of the leave of the court. There is two table in the,
no, you are now you are at stage of the appellate stage, na? That's
yes,
That's why you have come up with petition under section 320 subsection 5. That's it.
yes. Initially, it was filed by the respondent, means victim, in a form of affidavit. Form of affidavit that informing that the matter has been settled between the party during the pendency of the appeal. After that, this court has directed to file appropriate application. Already we have informed about the settlement to this court, my lord. After that, this court has directed us to file appropriate application. So hence this application is being filed.
In otherwise, my lord, it may be more appropriate if they file an application seeking leave of this honorable court in order to consider that IA, my lord.
And the question is that you have come up with petition under section 325, it's okay, it is for compromise and all. But it should be in a form of leave petition. That means leave is required before filing or before compromising the matter. Simple matter is that doesn't say so. So this I will be here, but a leave petition is required actually. Who to compromise to get the matter compromised at the appellate stage. Does the order, you can see the order speaks in that manner only. Otherwise you have to find the present I only to, for the compromise. That is.
Your Honor, I am representing respondent number 2. I am the
Yes,
victim.
I have understood. Respondent
Yes.
number 2 is there. She has already filed a petition or
Yes.
affidavit before the learned court below.
Yes.
Stating the matter has already been compromised and learned court. Rightly pass the order that you can approach the appellate court. That is okay.
Yes, Your Honor.
We are not on that. If the matter is compromised, that okay. But the procedure, compromise is better at the appellate stage. That is the minimum procedure. Which has to be followed. That is the main question. Otherwise, I don't have any.
Maybe because my lord, this is a compoundable offense.
Ah.
That is the reason leave is required, madam.
Yes.
Otherwise, if it was a non-compoundable offense, they could have invoked section 482 when the appeal was pending, my lord,
Yes.
as per the authority.
Yes.
My lord, for the interest of justice, this matter may be disposed of on the settlement matter.
No, that's what I'm saying. We are not against the settlement. You can file it tomorrow also. We are going to hear the matter. We want to dispose it. We are not finding this one. This simple procedure you have to follow. If application you file in the form of separate item, ask the registry to list it tomorrow. Only. We can dispose.
Matter may be listed for tomorrow, my lord. I'll file the application tomorrow itself.
Okay, that list tomorrow. Okay, it will be listed tomorrow. In the meantime, so we today only, you file it.
Hearing wala na. Eh?
After no.
Come back at 2 minutes.
Yes,
It's already one.
this is item number. Huh? We started. We'll hear two.
Yes, yes.
5 minutes left only. We'll not pick up.
Chamadare, Ahale.
You are for the appellants.
Yes.
Yeah.
But this RFA is directed against the impugned judgment and order dated 2012-2019, passed by the learned district administration Judge West Kamek in title suit number 03/2017 on two basic grounds. Number one, there is one deed of agreement, that was not put into challenge. One.
Deed of agreement.
Yes. And then number two, the husband was not made as a party. Here, what had happened was the husband reached the wife along with the children in the ancestral home of the husband.
Yeah?
In
Yes.
the ancestral home of the husband.
Acha.
So she is growing up, the children's two daughters, beautiful daughters. They came to me also. I met them and tried to find out what is the reason why your father reached. So probably after that, and suddenly he appeared somewhere in 2017, after a gap of 16 years. So then that is the fact. Well, basically, like kindly come to the impugn judgment. But otherwise, my lord, the fact still is that house is still, some portion of the house is still under possession of the applicant. Yes. And collecting the rent. But here, my lord, what had happened was, if that agreement dated 05/07/2017 was not challenged, it is because of the mistake of the advocate. Because my lord is aware the intricacies in our procedures, and as a layman will not be knowing, and for that reasons the learned court below has held to that extent. And secondly, that non-joinder, that is purely, that means purely on technical ground. But we kindly come, fact based on team, the impugn judgment. Once I read this, and I'll just place few authorities, and then my brother Soki will also advance his argument. I'll not take. The fact we need to understand in this case is this: the brief fact of the case. Oh, the brief fact of the case fact is that the plaintiff so and so has filed the suit under Order 7, Rule 1 and Section 20 of the Code of Civil Procedure 1908 for declaration of title, ownership, interest, and confirmation of possession of RCC residential building located in Manpat, Lumla under Circle PS Lumla, District Tawang, and also prayed for permanent injunction against the defendant and his agent. As per the plaintiff has married with Lobsang Panjur in the year 1999. Since marriage, the plaintiff has settled matrimonial home at Manpat, Lumla, and born 2 daughters out of their wedlock. It is asserted that she is living with 2 daughters in the matrimonial home with husband, as the husband has settled in Italy, in a foreign country. The husband of plaintiff never looks back the plaintiff and completely neglected the plaintiff and 2 minor daughters. The defendant is the elder brother of her husband, and he is also settled at Manpa, Lumla. The husband of the plaintiff is the 7th number and the youngest of amongst the brother. The defendant has 7 brothers. The plaintiff has claimed that the sweet land is in her possession since 1999, from the time of her marriage with her husband. The properties of her father-in-law located in Lumla, Manpat, Bomdila, and Tawang Township have been duly divided amongst all the brothers of the defendant before the death of her father-in-law and the father of the defendant. My lord, we just mark this particular point, divided. Whereas the learned court below, finding of the learned court below is something contrary to this. The father-in-law died in Lumla in 2014. The plaintiff has stated that once in the month of June 2017, this line also, because the husband appeared. The husband of the plaintiff appeared suddenly in the matrimonial house after long gap without any knowledge of prior information. It was come to know that the respondent has surreptitiously planned to divide the matrimonial home where the plaintiff and 2 minor children are residing. This is important. Some mens rea is being shown here. That means there was a motive and preparation to divide the matrimonial home property. When the matter was informed to her husband, but she did not get any positive help and support from the husband, she was literally asked to give up property in which she relied. It is established that there was a conspiracy hedged by husband himself. The defendant is well settled and recognized person on the society who still enjoys his own share of property distributed by the father. As such, the defendant has no right to claim the sweet property. The plaintiff has not been given any other properties by a father-in-law except the sweet property for her maintenance and two brought up children. The cause of action arose when the defendant demanded the part of Sweetland in the year 2016, which the plaintiff is in peaceful possession for last 17 years, and when the defendant started threats and mental harassment to dispossess the sweet building and to render the plaintiff a homeless. Therefore, the plaintiff has prayed for declaration of right, title, interest, and so. My lord, kindly see the peaceful possession for 17 years. That means law of adverse possession. I am holding it. And in between, the husband appears in the month of June 2017 and executed this 05007-2017 agreement. So that WS has been filed and all, then this paragraph is also important to read. The defendant have filed WS and also made counterclaim. That is order 8, order 8 CPC. According to him, the sweet property is not the matrimonial home of the plaintiff, but it is an undivided property amongst the brother. The land of sweet building was purchased by his father and the sale deed was executed before JMFC Lumla. After the marriage of the plaintiff with brothers of defendant, they were allowed to stay in 3 rooms in the first floor of the building, but no exclusive right of possession or title over the building and land was given to the plaintiff, which is known to her husband. Meaning there were the 3 rooms. That's why I said they still is in possession of the applicant here, the defendant, plaintiff in the incident. Now the problem appears to have started from here. The father died on 10/4/2014 and the husband of the plaintiff was in Italy. As such, the division could not be held at that time. The rival contention is. After arrival of the plaintiff's husband from Italy in the year 2017, both the brothers, after obtaining consent from other siblings, mutually divided the building by executing deed of agreement dated 05/07/2017. As I said, coupled with some intention, suddenly the husband appears after 17 years and then get in conspiracy with other brothers to dispossess the property properly, virtually rendering the plaintiff and 2 brought up daughters, biological daughters. So this is what I find here. Then that I'll not read. Now Milord will only kindly come to this. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, then 18 line.
18 line.
The defendant has made counterclaim that the rent was collected by father, but 3 rooms of the second floor was allowed to collect by the plaintiff for upbringing the children. So even if not, if this matter is remanded back for 2 reasons. One, that was not 5/7/2017 sale of deed was not challenged. And secondly, non-joinder of the parties. Then also, under law of adverse possession, the applicant and plaintiff in the title suit is in possession of the land. So law of adverse possession will come to our rescue. But such concessions did not acknowledge the absolute ownership of the plaintiff upon the building. The original sale deed dated 24/5/1996 and the sketchmap of the land are in custody of defendant. When here the problem is, because all these documents were with defendant. The defendant has alleged that the plaintiff is wrongly collected the entire rent The defendant has requested several times to the plaintiff to share the rent equally, but the plaintiff did not agree. Therefore, the arrangement to divide the property made on 057/2017. And a half the two-story building, 3 rooms I am collecting. So, single mother trying to bring up 2 daughters. Even they want to dispossess me from here. So very unfortunate. Now, my lord, kindly come to his 23, my lord. Submission of the learned counsel. Page 23, my lord.
23 of the judgment or?
Judgment. No, in the appeal itself, it is
Like resolution is.
RFA, my lord.
No, RFA is all right. Resolution is a bit thing.
Page 4,
Anyway.
page 4 of the judgment.
Page 4.
Yes, internal page. I'm so sorry, my lord, if there is some defect.
Resolution is not there. Anyway, page 4, submission of the.
Yeah, submissions. The learned counsel for the plaintiff submitted that the plaintiff was given to the suit property by her late father-in-law to inherit the suite building. The husband of the plaintiff had deserted the plaintiff and left for Italy country, and he never returned. As per the customary practice, here the conflict, my lord, will find the procedural and the customary law. There's conflict I am able to detect here. As per the customary practice, the house where the parents resides belongs to the youngest son of the family, correct? That is fine. So at least I am your legal wife. We are blessed with 2 daughters. At least I have. And my lord, there is one judgment. Even the illegitimate child also has a right to seek property of the father. So that I forgot to bring. When we dissect this kind of order, then this proportion comes out. Till his last breath in the suite building, the plaintiff has developed. My lord will mark this also. I have also developed the land. The plaintiff has developed or constructed the top floor of the building as the father-in-law declared the suite building in her name, Barbel. Now, my lord, when the word Barbel is there, in terms of customary practices, my lord, that is the final law. But again, when we come to the procedural law, this will not fit into the scheme of section 3 of the Indian Evidence Act. So the real conflict, should I take the verbal declaration on the face value, or should I need to adduce the documents under section 3 of the Evidence Act? Documents, it is section 45. Section 45 of the Evidence Act. So in that case, the suite property. Now, this is very interesting part. After Barbel, the suite property is in possession of the plaintiff immediately after the death of the father-in-law and collecting the rent. Here also the one of right that has been accrued to me legally. It is also pointed out that PW2 at para 6 of the cross-examination clearly deposed the practice of customary law. No dispute on this, and even no quarrel. The burden of proof lies with the defendant that the husband of the plaintiff came to Dhiran and executed the DPX2. The defendant has not able to produce the magistrate and the husband of the plaintiff to prove the authenticity of DPX2. In the absence of the proof, the authenticity of DPX2, the document is to be rejected. Now, my lord, what is the power of the court to summon the witnesses? My lord will just turn to order 14. Order 14. There is a power. Summon, call him. But how a plaintiff will call a magistrate to give a deposition? No, this is the wrong recording. Therefore, the plaintiff prayed this court to declare the right, the interest, so and so. Now the other side, the para 5, the learned counsel for dependent on the other land submits that the DPX2 is not challenged by the plaintiff. And thereby the suit is liable to be dismissed under Order 6, Rule 17. Now, Order 6, my lord, it is pleading. Generally means plain or written statement. There is one thing, there is the definition. Now, that Rule 17, my lord, court may any stage of the proceeding allow either party to amend or alter the pleading, my lord. Here, the landed court ought to have given an opportunity, my lord. Now, when you refer to these two rules, then and there, my lord, would have given the opportunity saying that, no, there is a provision under Order 23, Rule 1. The plaintiff can withdraw the plaint by making an oral submission or by means of a miscellaneous application to allow alter amendment. So here, the learned court below has technically gone below. Right? The law is well settled. On the garb of technicalities, the right of the petitioner should not be denuded. That is the law. I'll place that. It submits that the plaintiff is claiming the suit property indirectly on the strength of her husband. Correct. What is the wrong? My husband is still alive. He is staying in a foreign country. But that before 2017, Milan, 5/7/2017, Milan, my husband has not executed any gift deed. So thereby, I am the guardian now as a one part of the soul. I have every right. So indirect inheritance to the husband is not sustainable when the husband has divided the sweet property to defendant. So therefore, this technical glitch should not deprive the right of the plaintiff. Now, next page it says that the father-in-law collect the rent and all this. I have not referred. My lord will kind to 6. The interesting finding by the learned phone below during course of hearing. Very interesting. Then the 7 is framing of the thing, and then I'll not go much also. During the course of the hearing, some admitted facts are recorded as under. Properties were divided amongst the sibling of the deceased father during his lifetime. Correct? Properties was divided. It was with my husband, and I was in legal possession of that property first. Date of dividing partition of property is not known to the parties. Correct? Because that time, that's why difficulty in the oral tradition. When you go by the oral tradition, it is by declarations only by mouth without executing any instrument. So this oral tradition, these are two beautiful things. The greater tradition and the small tradition comes. Say, kindly see that Nalbari, the Assamese, the phonetic variation is there. In Nalbari, Jaishila, Khaishila, that because I have been to that area, at Tumikot Goishila. That is in the North Assam. So that what happens, the oral tradition also travels by the traditions. So the nearest will have the influence over, that means the greater tradition will have always influence over the small tradition. So therefore, this is what exactly is not known because it was done by oral, verbal declarations. 3, the plaintiff has no claim on the properties of the deceased father. We are saying no, we are not also claiming. The deceased father has 6 or 7 sons, and the husband of the plaintiff is the youngest. Now, my lord has seen in the previous recording of the learned court below that as per Bompa customary law, the youngest son would be the immediate owner of the father's property by means of inheritance. And this is a custom, It is not even recorded in the form of instrument, nor the registration. The plaintiff was the deceased father till his bred under the same roof. Now, this is the beautiful fact in the learned court below the record. The court has framed issues on the consent on both the parties as under. This we'll read and then I'll come to the finding. I'll just indicate those. Whether any cause of action arises for filing the present suit. Whether this is normal, whether this general question always be framed. Whether the plaintiff is entitled to any relief in respect to property in dispute, whether the suit is maintainable or not in the present form, whether the property in question is undivided, family property of so and so, whether the plaintiff is in possession of entire property in dispute since 2007-14, whether defendant possessed 3 rooms at second floor of disputed property since 2014, whether any family arrangement has been reached while agreement dated 05/07/2017 in respect of the property. Now, my lord, just issue number 1. Issue number 1, my lord. Para 9, issue number 3 is in my favor. That's hence the actually disputed by the defendant in pleadings, evidence as well as arguments of the learned counsel. Hence, the issue number 3 is not a disputed fact. Therefore, no discussion is required on the admitted fact. Now, what was that? Property was divided among the families. This first issue number 3 has gone in my favor. Now, issue number 1 is important. Collecting the rent or not. It is in my favor. Next page, kindly come. The finding. Hence, I am of the view that the plaintiff has cause of action for filing the present suit against the defendant as he has the possession of the suit building since 2014 after the death of father-in-law, and the cause of action started when the defendant started claiming the suit property on the strength of agreement dated so and so between the defendant, the husband of the plaintiff. In view of the above fact, issue number was decided in favor of the plaintiff. This is also in my even after Milord, the court has founded that 5/7/2017 agreement. I am collecting the rent. Issue number 4, Milord, it is also in my favor. I'll just undivided property, and then I am having the second floor of the building as an alternative resource. So now I'm going to kindly come to para 12. This is important, para 12. On the basis of the issue, on the basis of framed issue, the plaintiff is to prove the fact that it was a part of divided property and the suite building comes under her share. The defendant is disprove the fact it is not divided property and the suite property does not come under the share of the plaintiff. The possession of the suite building is in favor of the plaintiff as decided in issue number 5. Now the possession of the building is under me. It is also fact that the plaintiff is residing in the building, no dispute, with the deceased father-in-law since 1999, and she has also constructed a rooftop building on the suite property. No dispute on that. Now, other part, this is also, it is in my favor. Now, my lord, 13. Now, considering the evidence of the plaintiff defendant and also taking into account of the admitted facts, I find that the plaintiff has failed to prove the fact that the building was exclusively given to her by the deceased father as the collection of the rent by deceased father till the end of his life leads to show that the suite property is undivided till end of deceased father. This is a contrary finding. This is contrary finding. Already decided issue number 5 that everything I'm residing with my father-in-law, I'm collecting, I've constructed a house. This is in view of above fact, the issue number 4 is decided in favor of the plaintiff. Well, let us see what is this issue number 4. Whether the property in question is undivided and family property of late Roger Agnes. This is only. Then he says, para 15, As regard to issue number 5, whether the plaintiff is in possession of entire building, it is specifically admitted by the defendant in his affidavit and deposition and also in cross-examination that the plaintiff is collecting the rent of the entire building after the death of his father. Therefore, the intent issue is nothing to discuss further, and accordingly, it is conclusive that the entire building is in possession of the plaintiff since 2014. Now, when the building is in my possession, any gift of deed executed on 5/7/2017 is nothing but a fraud. And that should not have been taken on the face value of it. Because the husband of the plaintiff was in Italy. And in 2017, he comes back and do this kind of this mischief. I think this gentleman is a heartless fellow. Even has not thought about the future of two daughters. Forget about me, Milord. Forget about me. At least he has a social and legal responsibility to look after the children's house. Which he's a bad father. This should not happen with any of the child, any children in lifetime. So this is also in my favor. So once this issue number 5 is decided in my favor, that means I am the absolute owner. So therefore, any this thing, that also that even the issue number 6 was also in my favor. Issue number 6 was relating to possesses 3 rooms at 2nd floor. There also, my lord, will find next page, kindly come. Page 29. As such, the possession of 3 rooms by the defendant is not proved, and the instant is covered by the issue number 5. Hence, issue number 6 is decided in favor of the plaintiff against the plaintiff. It is in my favor, my lord, everything. But now, my lord, para 17 is the one which is something very this, can we just have a look at paragraph 17 also? I'll not read, just my lord will indicate. This is only on the question of whether issue number 17, 7, whether the family agreement, whether family agreements made an agreement dated 5/7/2017 was executed in respect of said suit. Now, what only ground which he says is, the learned court says it appears that the plaintiff has aware of sudden appeared, I think this English with great respect for sudden appearance, it should be appearance of her husband in the month of June 2017 in her house without prior information and knowledge, which she has reflected in her plaintiff para 8. When the claim of the defendant was informed to her husband, she was asked to give up the property and did not help the plaintiff to resist the claim of the defendant. The plaintiff has not annexed or enclosed the agreement dated 5/7/2017. Now, from where do I get this? Everything has been done surreptitiously behind my back. So from where do I get this? So that's it happened that this is here, it is hard in law. This is completely a erroneous finding in law. Now, that's why that particular issue number 7 is decided against me, except because I am not aware of the execution of the deed of agreement executed on 5/7/2017. I am not aware of what has happened in a watertight compartment, and I am not aware. And it is all behind my back. Now, this now, Melon will only see this. I'm concluding with because in the appeal, Melon only we have to examine the factual position and correctness of the finding only. and the procedure. So whether I am burdening, hope my brother will also not refer too much. He'll only question the law. My lord will kindly come to page 31, internal page 12 of the judgment. The fourth line, my lord, will mark on the basis of the law. On the basis of customary law and practice, the plaintiff is entitled to get all the share of property. Again, my lord, customary law, it says the learned court below is, I think, swimming in between. No? On the basis of customary law and practice, the plaintiff is entitled to get all the share of property which would have been belongs to her husband. It is also observed that the husband is already deserted the plaintiff in 2001 after marriage and never came back again in the life of the plaintiff, and suddenly appeared in 2017 after the demise of late father and settled his share of property with the defendant is not justified in the eyes of law. Since the husband has deserted the plaintiff and daughter, he has no right at all, as per Mompa customary, to claim settle the property with the other sibling of deceased father. But here it is, therefore, the agreement itself is void ab initio. Now, I could not understand whether the learned court below was adjudicating this matter under the CPC or was adjudicating the matter in a customary court. This differentiation will observe. And I have been ousted from my property by wrongly applying the customary code, the customs. Unfortunately. However, the plaintiff has not made any prayer to declare the settlement of her. Here the finding goes. However, the plaintiff has not made any prayer to declare the settlement of her husband on the shared property as illegal and null and void in terms of their customary law. This is unfortunate. When at the first place, you are applying the CPC and you have held that the entire property is under my possession, immediately could have resorted to the law of adverse possession and declared the title in my favor. In view of above below, that kindly mark this column only so that my lord will have this. In view of the aforesaid para 19, now I am concluding with this fact on the judgment. In view of the aforesaid discussion on issues, I find that the instant suit has got a merit to file a case. My lord will mark this, very interesting. In view of the aforesaid discussion on issues, I find that the instant suit has got a merit to file a case against the defendant and her husband. Now, that means what? It is the learned court below has indicated that yes, you can institute a fresh suit. The remedy has been given. Now the question will come, even if there is a remedy, I will be hit by the section 5, section 6 of the Limitation Act. So for that purpose, even may not go into the, even may not interfere into this impugned judgment also. Then remand the matter back and allow the petitioner, allow the defendant below, in the learned court below by invoking all the is right. Allow her to withdraw and file praise by adducing this document. The genuineness of this has to be tested. That is because documents that comes under section 74. Because once it is executed before the any magistrate, executive magistrate, it becomes a public document, what is defined in section 74 of the Evidence Act. So that is what here this is marked. And her husband, however, the suit is suffering from legal infirmities as described other. Now, infirmities is technicalities. First of all, the plaintiff has not challenged the agreement dated so and so as illegal in the plaintiff for declaring it to be null and void. B, Secondly, the plaintiff has not made her husband as a party to the suit for illegally transferring the suit property in favor of the defendant against the wisdom of the father-in-law. That is order 1 rule, 9 and 10. Joiner and misjoiner of the parties. So at least this should not have been the ground to dismiss the title suit on technicalities. Now, let us have order 6 rule 17 for a moment. Okay, order 6 rule 17. Now, what happens? This is one provision in the CPC where at any stage of the suits, court may direct the party to alter or amend the plea. This has been done away with. The court, I'm just reading for this for the purpose. The court may at any stage of the proceedings allow either party to alter or amend his pleading in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real question in controversy between the party. Now the question is, here, that's why I said the entry cases of the court proceeding is this, that proviso. Provided that no application for amendments shall be allowed after the trial has commenced, unless the court comes to conclusion. But then again, there is a rider. It is not couched in a negative language. Unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. There is a provision. So therefore, that order 6 rules 17 was not properly appreciated by the learned trial court while deciding this. Now, we'll see this. Did not file, again, the third technical defect is that the plaintiff did not file rejoinder to the WS of the defendant on counterclaim. That's purely by mistake of the counsel. At least the counsel is there. A person who is technically and legally trained, it is duty of the counsel to advise me, look, I have to file this. Now there is a fault of counsel for not giving proper legal assistance. Now, the plaintiff has also not made any grievances in her deposition to declare ignorance. So, in the absence of 20, the finding is, in the absence of any claim made by plaintiff in her plaintiff, and also in the evidence, I am not inclined to interfere with the agreement dated so and so between the parties. The interference on the agreement would invite beyond the pleadings of the party, which in turn would alter wires of the issues of the case. Accordingly, the suit is rejected and dismissed on technical grounds. Now the finding is there. As I pointed out, I place those judgments, I will not read also, but I just indicate the paragraph. On technical grounds, 1995, I will provide it. This copy I have not got, my adjustment. 1995, supply 4, 681, paragraph 4. The issue is on technical ground. That because of technical or procedural defect, the plaint should not be dismissed. Now, 1999, 3 SEC, page 267, para 10. Court cannot dissect the plaint partly. Now, as Malor has seen, except for issue number 7 and 2, all the issues are in my favor. And finally, the court has come down and dismissing my title suit on technical grounds. No, this is not permissible. 1999, I have printed, just I provide this copy. 1999, 3 SCC. Para 10. Muy bien. It says, just I have marked this. It is elementary that under Order 7 Rule 11 ASCPC, the court cannot dissect the pleading into several parts and consider whether each one of the dissect the pleading into several parts and court cannot dissect the pleadings into several parts and consider whether each one of them discloses a cause of action. There cannot be a partial rejection of the plaint. So virtually is a partial rejection of the plaint and then dismiss it. Similarly, this I'll provide this. Technical glitch, 2011 1 SCC page 121. I'll provide this paragraph 14. I'm indicating this for for easy of my lot to understand. Keeping in view the well-settled principle laid down by this court that technicalities should not defeat rendering of complete justice to litigant. We think it appropriate to remand the matter to the tribunal to verify and consider whether certificate which so and so. That this on this principle, just I'm indicating para 14. Actually, this morning, yesterday, what happened, both of us were in conversation, where the person who engaged me says, you withdraw the plaint, and then suddenly at 8 o'clock in the morning, the appellant calls me up, no sir, either ho, udhar ho, case ko khatam kar do. Then I just have to again call my brother Soki. I have told you yesterday that I have been instructed to withdraw the plaint. Again requested him please go through for 1 hour or so. Well, that is, that's why I could not properly, chart out the list of book. This 2018 11 SCC 780. But there is one more judgment in this on technical glitch. 2019 it is there, but I will not rely to it. Paragraph 3 to 6 and 9 and 11. Let us read together this paragraph 10 and 11, if my note allows me. I have taken, I have taken a lot of time. 10 and 11. In contrast to the above provisions, which apply on a demeanor, the provisions of Order 14 Rule 2 read as court to pronounce judgment on all issues. These, supposingly, here few issues were not dealt with by the landed court below us, and the issue was not discussed. On this count, that paragraph 11.
Issues have been discussed, I think.
They have 1 or 2 issues. I think there's a missing. Yes, my lord will verify this because I may be wrong, Lord. There's ultimately because of that, it was quashed and set aside in the paragraph 11, and the matter was remanded. So, my lord, this lady, 2018 to my lord, I have given it.
Yes, yes.
So, my lord, the apart from this legal fictions, my lord, Order 41, Rule 27 need to be appreciated. Production of additional evidence in appellate court as an exception. Now, this was also not being dealt with. Now, Order 41, my lord will also see just Rule 32 and 33, power of appellate court, my lord. So where my lord will have the power, what judgment may be direct, my lord, and then power of appellate court. So that's Order 41, Rule 32 and 33, invoking this, my lord, because in view of the recording of the, I have referred to Order 41, Rule 27, my lord, then 32 and 33. Then, my lord, that's why in view of the finding at paragraph 19 itself, and my prayer that I have advanced, my lord, my ground for challenge is set out, my lord. My lord, just I am indicating, I'll not read anything, my lord. My lord, para 8, page 7. My lord will only the important paragraph that my rule is 1 and 2, it is already there. CD, my lord, CD at page 8. Johnsburg. F and G, my lord. F and G. Then, my lord, I may also be appreciated. My lord, this J, I think I have quoted the judgment. One judgment I have quoted, my lord, that J at page 13. For the appellant, for that the appellant had engaged her counsel to represent her in the suit and advise her appropriately accordingly. However, due to lack of proper advice on the part of her counsel, the appellant was deprived of an opportunity to submit her written statement counter to the counterclaim. It is the settled law of the land that the party must not suffer on account of neglect of the counsel, since the lawyer is not an agent of the party. The negligence of the lawyer should not be equated as negligence of the party. Judgment so and so. The learned counsel below have failed to consider this aspect of the matter in the proper perspective and erred in holding that no relief can be granted to the plaintiff as the suit suffered from serious legal infirmities, more particularly as the plaintiff, the stroke applicant did not file rejoinder to the documents. So that with this, Lord, I conclude. And my respectful prayer is to remand the matter back.
Yes, my lord, in fact,
Well, my brother will continue to submit. My younger counsel is here. I will not make any rejoinder. Because in this case, my lord, tentatively what I have found is, even if I win, nothing is going to affect him. Even if he wins, nothing is going to affect. That is my tentative finding in this case.
Well, it's true, my lord, that yesterday my elder brother, he called me up. He said, I'm going to withdraw. You need not read, go through the brief. This morning around 8:30, again call me. No, he wants the appellant wants the matter to be heard. Yes. So basically, I will not, your lordship, I will not take your lordship through all the merits of the case, which has already been addressed to me. So basically, my lord, what has happened here is that the learned trial court came to a finding that there are certain things which have not been challenged, and basically what he has done is the district judges dismissed it on technical grounds, and after that, that order has been passed. My lord, if you lordship has seen it, page 14. My lord.
Petition would have been filed before the learned court below regarding if suppose the agreement
Yes,
is in possession of the defendant.
my lord.
That order court could have passed an order to produce it.
Yes,
That was
my
not
lord,
done.
of course, my lord, that was not done, and then otherwise also that order 6 rule 17 also where the amendment is to, my lord, it is not the duty of the court to order for the amendment, it has to come from the parties. It is all there, my lord. Basically, what has happened is that on that ground, my lord, that basically it's a rejection on the plaint only. And as admitted by my brother, that all the issues on the rights of the parties have not also been determined, my lord. And by this judgment, it has been dismissed, and then some order has been passed at page 14, my lord.
As per you also, all issues have not been discussed.
Yes, my lord. The rights as such, my lord, admitted by my brother, my lord, who just now completed this, Mr. Tara, he also admitted otherwise, that all the issues have not been determined also with regards to the rights of the parties. That is what the judgment has done, my lord. Judgment and the order, basically the order is there. The order only says it has been dismissed for technical ground, rejected. Basically, the plaint is rejected and dismissed, madam. But that is what the order says, madam.
Mainly on technical grounds.
Yes, madam. This is at page 14, madam. Or page 33 of the appeal, madam.
Please.
33, 3333, madam.
Your presentation is not.
Oh, madam,
Anyway,
that's
one page.
internal page 14, madam,
Ah,
of the
yes, yes.
judgment.
Internal page must be the 13.
13 and after that, the 14, madam. This is the judgment and 14 is the
Acha,
order.
order is there.
Order,
huh?
order
Yes.
is there, madam. Now, madam, whether that adverse position, all those things, madam, I will not go into those, madam. Adverse position also, madam, knows, madam, it's not absolute, madam. There are exceptions to it. My wife
They
is
have not
staying.
taken the plea also in adverse position. They have not taken the.
No,
plea of
my lord,
adverse
no, my lord, it's nothing there, nothing is such. And otherwise also, my lord, adverse position also, my lord.
Mm.
A person is staying in my home, my lord, with my consent, my lord, it will never amount to adverse position, my lord. I'm not going to this. Now, my lord, this appeal has been filed under, my lord, section 96, my lord. Section, this appeal is under section 96, my lord, of the CPC. My lord, if your lordship would come, just take, see section 96 for once. My lord, knows this after the trial, my lord, the judgment is there, and then after the decrees are drawn, my lord, whereby there is the formal adjudication of the rights of the parties are done through the decree, my lord. Now this section 96, my lord, it says appeal from original decree, save where otherwise expressly provided in the body of this code or by any other law for the time being enforced. Appeal shall lie from every decree passed by any court exercising original jurisdiction of the court authorized to hear appeals from the decisions of such court. So basically, my lord, such appeal, this appeal under section 96 has to come from a decree. Yeah, in this case, my lord, nothing is there. It has been dismissed, my lord, on the technical ground.
No, I don't know why, what kind of order is passed, let us see, page 40, 30, you're on page 30, 33.
33, ma'am. Internal,
33.
yes, ma'am.
Uh,
Case on technical ground, as such, the
So
suit is
there
liable
is
to.
no order on preparation of any decree.
Yes, my lord, there's nothing, my lord. I've gone to the records, so no decree is there, my
No
lord.
decree
Because,
is there.
yes, my lord, because this is dismissed only on technical ground, ma'am. So I will stick to that point only, my lord. Here, when it has been dismissed on technical ground, there cannot be bar to a, my lord. When my brother Tara was also submitting, my lord, in paragraph 19, the learned trial just says, my lord, maybe you have a case, but due to technicalities, I'm rejecting this, my lord, rejecting the plaint, man. So under the circumstances, my lord, there could have been, my lord, I'm not want to suggest, my lord, what remedy is safe, my lord, but they could have filed a fresh suit also, my lord. Now it was urged, my lord, by my brother that section 5 limitation is not that of course cannot be held, my lord, by this court, my lord. When my brother says due to limitation I could not file even, that cannot be there cannot be a shortcut, my lord, to circumvent that limitation that is prescribed, my lord. If there is something there, the lower court where the trial is.
What do you want to say in regards to prayer for remand?
Prayer for
Is there
remand.
anything to?
No, my lord. First of all, I'm saying that, my lord, since no decree has been, this, in fact, this appeal would not be maintainable. That's my basic argument, my lord. So I will only stick to that only, my lord. Remanding and all, my lord, will first, my lord, see whether your lordship that even if the appeal lies, when the rights of the parties have not been completely, my lord, adjudicated, and there is no formal expression of such rights of the parties, my lord. No decree has been drawn up. Only certain order is there that I am dismissing your suit, my lord. Then whether this appeal under the section 96 would lie, that is what I would rely on. First, my lord, I'm relying on 1999 volume 4, 89, my lord, SCC 89, my lord. It's paragraph 9 and 10, man. '99 volume 4 SCC 89. Paragraph 9. my lord. Every suit, if it is not withdrawn or abandoned, ultimately results in a decree as defined in section 2.2 of the Code of CPC. This definition, so far as it is relevant, is produced below. Decree means the formal expression of an adjudication, which, so far as regards the court expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit, and may be either preliminary or final. It shall be deemed to include the rejection of a plan, and the determination of any question within section 1, but shall not include any adjudication from which an appeal lies from an appeal from an order, or any order of dismissal for default. 10, explanation is there. 10, thus a decree has to have the following essential elements, namely, there must have been an adjudication in a suit. The adjudication must have determined the rights of the parties in respect of any or any of the matters in controversy. Such determination must be conclusive determination resulting in a formal expression of the adjudication. That is the one. Another one is the same thing, there was just for reference, this is 2009 volume 2, SCC 562, to SCC 562. Just paragraph 15 and 16, where also it says that there should be some adjudication with regards to the rights of the parties. Such determination should be conclusive, and there must be formal expression of such adjudication, which would be called a decree. In this case, there is no decree. Only some order has been passed. And when this suit has been dismissed, on the technical grounds, there lies no bar to the plaintiff, to file a fresh suit. It could have been done, instead of going and taking the route through this honorable court, as my brother has said, let this go back, then we may be allowed to amend, we may be allowed to withdraw. That, to my very limited and humble understanding, that cannot be done, So to facilitate the filing of the fresh suit, when he says remand the matter and I will withdraw, we will file a fresh, that can still be done, there's no bar as such, because there is no decree as such till date, Only the finding is that since it is not technically feasible, I am rejecting the suit on technical. That is what the court has said, and the order is also there. So that order is not a decree, where it says I'm dismissing only on the technical grounds. So under these circumstances, this appeal would not lie. That is the only point I would like to urge before your lawsuit. I'm not going to the merits. So basically, this appeal would not be maintainable. That is my basic ground. In the absence of any decree being drawn, because decree cannot be drawn in this case, where he has merely dismiss on technical grounds and pass an order saying that this is not technically right. The other says, yes, the remedy, my lord, there is no need to meet for this court to send it back so that he can withdraw and file afresh. He can always file afresh, my lord. There's no bar as such because there is no decree. He can still file afresh, my lord. That is my only.
That only when that's technicalities should not defeat the right of the litigant. That proposition I got to remember only. That's why after making a submission, I pointed out that even if my brother wins, or if I loses, or if I win, if my brother loses, nothing is going to happen in this court. But I only
Because
this.
ultimately there is no executable decree also.
Yes.
My lord, there's no decree as such,
Only-
my lord. There's nothing. Only that order says, your lordship has seen the page 33. It says, I'm dismissing your yeah, on technical ground.
on the-
So there's no decree and
And-
such no appeal would lie. My lord.
And only, my lord, even if either this way or that way, only, my lord, only liberty may be granted to the petitioner. So that delay part may not occur, my lord. Because of this, it is pending, my lord.
No, my lord, then it would be a very dangerous thing. Even your lordship condones the delay on behalf of the trial court. my lord. Let him appear there. The
My
court
lord,
below will decide.
Suppose, I'm not.
Yes.
defending the appeal. Suppose even if you file a fresh suit, suppose.
Yes.
In that case, it will be a suit.
Huh.
So limitation will count otherwise,
Yes,
not
ma'am.
the.
Yes, ma'am.
I mean, it will be part by some 3 months, 4 months, that category will not count.
Yes.
Definitely, it will be a fresh suit.
It would be a fresh suit.
It
of
will be a
course.
fresh suit and in that case, most probably there will you are will be at liberty to even to take the plea of adverse position.
That is what, my lord. I wanted that point out.
That is all.
Whether the plea of adverse position will, how far it will be
Yes, ma'am.
considered fact that will be decided.
That-
On other factors can. And that case, otherwise, I was also talking to him. That suppose the petition, the agreement was in the custody of, say, defendant. In that case, we could have made a prayer before the learned court below to direct the defendant to produce the, agreement.
No, that is what, my lord, this order 6 rule 17 was violated by the.
No, man.
Not order 6 rule 7.
Yes.
Production of the document, if the document is in custody of the defendant, then order, if it. an
Yeah,
affection is
that-
then
that-
court
that-
has the
that-
right to direct the.
Correct, my lord, because
That is-
misfault of the advocate who was conducting this case. Great. Great.